Hi everyone, this is Linda Olson with the Washington State Coalition Against Domestic Violence, and we are getting ready to start our quarterly conversations for shelter managers. I anticipate more people will be joining us in the next few minutes, but we are looking at a tight time schedule in the next hour. So Judy Chen is here with me at the Coalition office. She'll be watching for any logistical questions, and I'll be watching for other sorts of questions you might have, and Aaron Dunn with the Northwest Justice Project will be coming on in a little bit as our chief presenter. Just in terms of questions you might have about the logistics. Let's see if I can. Right, there we go. We encourage that you listen through your computer speakers, and remember to unmute your speakers so that you can actually hear us. Hope you've done that by now. If you've got questions, if you're having trouble hearing us, be sure and do a question or something in the question box. If your computer speakers do not work, if you don't have a microphone, be sure and select the telephone option on your control panel, and that should be showing up right now in your slide. Again, hope you can get the sense and message. Everyone right now is on mute. Please use the question box to communicate, and as I've already mentioned, Judy will be tracking the questions that are related to logistics and the technical aspects. I'll be watching for questions related to the content. Eric might also be taking a look at those too. We're hoping, since he's got a fair amount of conversation and content for you, that you start out mostly with clarifying questions. There will be time at the end for questions. If there is something burning, please don't hesitate to enter a question in the chat box, in the question box, and we'll make sure that it is addressed. There's a little instruction about the control panel and how important that orange arrow is. And finally, at the end of the webinar, there will be an evaluation form. Please, please, please let us know how it went for you, what your thoughts are. And of course, the first question asked is, who else from your program attended this webinar? We really need to know that. If you're sitting around the computer with a couple of other people, it is really important for us to know how many there are. So finally, just the agenda. We've already done our welcome. We know that Eric will be up, and questions and answers. And finally, we'll probably try and do 5 or 10 minutes at the very end, depending upon how much time we've got, to see if there are other burning questions or topics that we should either address or that we should plan for in the next webinar. We will schedule another quarterly call. It hasn't happened yet, but we'll be working on that and let you know. So I am going to go ahead and pass it over to Eric. Are you there?
I'm here.
All right, it's all yours.
Okay. Let's see here. Doing a little, it's not advancing here. Oh, there it goes. Okay, well, I pushed it a bunch of times, so hopefully it doesn't suddenly lurch forward. But first of all, I thought the best way to start off will be talking about what a landlord and a tenant actually are. Of course, there are different types of landlords. Residential landlords, of course, and then commercial landlords, agricultural landlords, etc. But since we're mostly going to be talking about residential landlords today, the state law called the Residential Landlord Tenant Act defines a landlord as basically the person who owns and leases a dwelling unit to someone. It also includes anyone serving as an agent of that landlord, usually a property manager. And the basic duties that landlords have, the statute goes into much more detail but the basic duties include making sure the property is fit for humans to live in it. That of course includes making sure it has functioning electrical and plumbing, that it's weather tight, heat, etc. Not interfering with the tenant's use of the property. So the landlord can, from time to time come and do an inspection or access the property to keep it up or to show it to new tenants or buyers, that sort of thing. But the landlord cannot unreasonably interfere with the tenant's solitude or use of the property. And then the third main duty is not discriminating against tenants based on their membership in any protected class. And in Washington, that includes victims of domestic violence, sexual assault, or stalking. Tenants, the term includes anyone who's entitled to live in a dwelling unit under a rental agreement. Now, there are some exceptions under the statute. Some of those are pertinent to shelters and so forth. One of the exceptions is housing that is incident to services. So, for instance, if somebody is admitted to a hospital for treatment, they may have some kind of a contract with that hospital, under which they would be occupying a room, maybe for a prolonged period of time. But even though you might be able to characterize that as a rental situation, the real reason the person is there is to get treatment at the hospital, not for housing. And so the legislature has recognized situations like that as not really being appropriate to characterize as landlord-tenant type relationships. And so those are excluded from the statute. Another major exception is what's called for transient lodging. These are places that hold themselves out to the public as hotels, homeless shelters, other types of facilities where the person is expected to stay only for a matter of hours or days and is not to become a tenant. A couple of other exceptions pertain to situations where someone is living in a apartment or some type of housing because they are working for the owner. Probably the most common examples are either a property manager who's residing in an apartment, as part of the job duties, or migrant workers or other agricultural workers who might have housing provided to them while they're working on a job site, or people who are occupying property in connection with a purchase. You might sign a contract to buy a home. Under some circumstances, a person might move in before the sale is closed. They're actually not a tenant. And when someone's not a tenant, as we'll see, the rules that apply to them can be a bit different. I'm having a lot of trouble advancing the slides here. Okay, there it goes. The main duties of tenants, as with landlords, the statute goes into a lot more detail, but there's basically three main duties. One, of course, paying the rent. Secondly, complying with relevant laws and reasonable provisions of the lease. And third, not causing damage to the premises beyond ordinary wear and tear. Now this is where things start to get a little bit confusing. There are basically two different types of tenancies. There is what's called a tenancy for a specified time. Usually that's when someone has a written lease agreement. They're going to occupy an apartment or some type of rental housing for 6 months or 12 months or some specific duration. It's actually possible to have a tenancy for a specified time without a written lease, but that's pretty uncommon. The other type of tenancy is what's called a periodic tenancy. Usually these are going to be month to month. The reason is that the term of the tenancy or the period is based on when the rent is paid. So if you pay the rent once a month, then you have a month-to-month tenancy. If you pay the rent once a week, you've got a week-to-week tenancy, that sort of a thing. But it's usually month-to-month. Now, there are a number of other types of situations which are actually not tenancies, even though some of the archaic language used to describe them sometimes includes the word tenancy. So probably the most common one is what's called a tenancy at will. This is a situation where someone is living in some kind of dwelling unit. They don't have a specified time that they're there for. They don't have to pay rent, and this may include, for instance, someone, maybe your cousin from out of state comes to visit and decides to stay there for a long time, and you let the cousin stay and don't charge rent. That person's not really your tenant, but it's called a tenancy at will. That term also applies to people who are occupying real premises in connection with a job. And as we'll see, some different rules pertain to people in these tenancy at will situations. They are not residential tenants. The Landlord-Tenant Act does not apply to them. Also, people who are occupying property that they used to own or that they claim to own. A common example that we see these days would be people who are living in a house that has been foreclosed, whether they are tenants of the former owner or are the actual former homeowners who got foreclosed. They don't have a landlord-tenant relationship with the new owner, and so they're not considered tenants. A tenancy at sufferance, also commonly known as a squatter. This is kind of just some random person that has occupied property. They don't have any sort of claim of, they didn't enter the property under a lease or with some right of ownership. They may have just moved in off the street. That's, again, the archaic term is a tenant at sufferance. They're commonly called squatters. And then probably the most important non-tenancy type situation that we're going to be talking about are what are called licensees. Basically, the legal theory behind this is that there are people who you might admit into your home or into a piece of property without the intent that they're going to move in and live there. They might be there to stay for a matter of hours or minutes or even overnight, but they haven't been given the opportunity to live there. The law considers them to have a license to enter the premises, and if the person who owns the property revokes the license, then they become a trespasser. So an example would be someone who is going to see a Mariners game or going to see a movie. They have a license to enter the stadium or enter the theater. If for some reason, their license is revoked, maybe due to some kind of misconduct, or the game is over, the movie's over, then they need to leave. Now, anyone who is a tenant cannot lawfully be removed from property except by a court order. The same is actually true of all these non-tenancy type situations that I mentioned: tenants at will, tenants at sufferance, people occupying under a claim of ownership, etc., except for licensees. If someone is a licensee, then if that license is revoked or expires, that person actually becomes a trespasser, and a trespasser is someone who can be removed by the police, basically. But any of these other situations, a person is a tenant or something resembling a tenant, and can only be removed by a court order. Now, there may be, in fact, there are situations, not uncommon, where it may be difficult to distinguish or tell whether someone is a tenant or a licensee. And that is basically determined by looking at a number of specific facts and circumstances. surrounding that particular situation under what an ordinary reasonable person would think. So if someone has a written rental agreement, they're on a month-to-month type situation, they pay rent or something resembling rent on a monthly basis. If the place looks like an apartment building or looks like rental housing from the street, there's not some sign in front of it that says Holiday Inn or Union Gospel Mission, where the person has their own dwelling unit. They have keys, they can come and go as they please, they have all their things there. That type of housing looks more like a tenancy, looks more like rental housing. And so that person is likely to be considered a tenant. On the other hand, if the person doesn't really have any sort of rental agreement, or they're staying there on a day-to-day basis, or something of that nature, they're staying there for free, or maybe with just a nominal charge. Maybe there's a sign out front saying it's a hotel. Maybe they're sleeping in a common room with other people. In say a shelter where you've got to show up by a certain time and basically stay there until the morning and then leave, or if you leave you can't come back, sort of a thing. All those types of factors are going to make the property look more like a transient lodging type situation where the person would be a licensee. Now, of course, if you have properties that have some of these factors and don't have others, it can be very difficult to tell which of these two scenarios that particular housing would fall into. It's probably best for landlords to err on the side of treating someone like a tenant. We'll see why in a minute. The way that people can be evicted or removed from premises, generally tenants have the right to a judicial procedure. At common law, which is basically judge-made law that arises from court decisions that really originated in medieval England, we didn't have the eviction summary proceedings that exist now. Landlords originally were allowed to use what's called self-help. Basically, landlords could get people out of their property by hook and crook, however they could do it, just as long as they didn't call what courts it didn't cause what courts call a breach of the peace. So the courts didn't want landlords causing fights or violence or things like that. So if the landlord could get someone out of their property without causing that, then that was perfectly lawful. But as you can imagine, someone being removed from property often did have the prospect of causing breaches of peace, and a lot of times there wasn't much landlords could do about it. So that situation didn't really work that well for anyone involved. So back in the late 19th century, Washington passed what's called an Unlawful Detainer Act. Every U.S. state has some version of this. They're all a little bit different, but these are statutes which create a very fast judicial procedure for landlords to remove tenants. In Washington, it starts with the landlord having to give some kind of written notice instructing the tenant to move out in between 3 and 20 days, depending on the reason for some reason the text is not coming up on this slide here. Oh, okay. The landlord has to give some kind of written notice directing the tenant to move out within by a specified deadline. For certain types of lease terminations, a tenant may have the opportunity to avoid eviction by curing the lease violation. So, for instance, non-payment of rent, the landlord has to give the tenant at least 3 days in which to pay the rent that's owed and preserve the tenancy. For most lease violations, the tenant's entitled to 10 days to come into compliance with whatever they've supposedly done wrong. But there are other situations such as serious misconduct, or in most parts of Washington, basically outside of Seattle, a landlord can terminate a lease on 20 days notice for no reason. So the landlord has to give that notice, and if the tenant remains longer than the deadline, the tenant is unlawfully detaining the premises. That's where the name comes from. The tenant's unlawfully holding over. So at that point, the landlord can bring a case in Superior Court. It's generally going to be heard and decided within at what's called a show cause hearing, which must occur between 7 and 30 days after the landlord files the case. If the tenant prevails at the show cause hearing, basically the court finds that the tenant didn't commit a lease infraction, didn't fail to pay the rent, has some type of defense, then the case will be dismissed. If the court finds that the tenant is unlawfully holding over, then the court will rule in favor of the landlord and issue what's called a writ of restitution. Even if the court rules in the tenant's favor, the landlord still does not have the right to go and physically remove the tenant himself or herself. The landlord still has to, only the sheriff can do that. And the writ of restitution is an order that the court issues to the sheriff, directing the sheriff to physically remove the tenant from the property. The soonest the sheriff can execute the writ of restitution is after posting a 3-day notice on the door. So altogether, between the 7 days for the show cause hearing and the 3 days for the sheriff notice, it takes a minimum of about 11 days to go through this eviction process. It can take longer, but if the landlord does everything as quickly as possible, it's about 11 days. Now, in the not so old days, if a physical eviction occurred, usually the landlord would just basically set all the tenant's belongings out on the street. The sheriff would supervise this, but a few years ago, Washington law was amended to basically require landlords to actually store the tenant's belongings, provided the tenant fills out a form requesting storage, or if the tenant is a person with disabilities and the landlord is aware of that, the form doesn't even need to be filled out. But usually landlords are going to have to actually store the belongings rather than putting them out on the street like they could in the old days. Now, in return for the summary proceedings, the ability to evict tenants in less than a couple weeks through the court system, Washington has made it unlawful for landlords to use the self-help methods that they could use in common law. And that actually is true even of these situations which are exempt from the Landlord-Tenant Act that I mentioned before. So even if it is transient lodging, as long as the person is not a licensee, self-help is impermissible. And summary proceedings are available even if it's an exempt type situation. Now, tenants at will, these are, again, the people who are, such as, the cousin who is just staying in your basement and decides not to leave. Tenants at will are not subject to the residential eviction procedures, but there are other court procedures that can be used to remove those types of people. They tend to take a little bit longer, not significantly longer, but it's pretty risky for landlords to resort to self-help. And also point out that in properties that receive any kind of public funds, particularly HUD funds or USDA Rural Development Housing funds or McKinney-Vento Homelessness Prevention and Assistance type funding and so forth, usually those recipients will either have a direct obligation to provide notice in a hearing before removing people under the Due Process Clause, or they'll at least have a contractual obligation to provide notice in a hearing because the agency that is funding them is bound by the Due Process Clause. And so if a landlord in one of those types of properties removes somebody without providing notice in a hearing, there's also a possibility of a due process violation. And so the unlawful detainer procedure is pretty much always going to satisfy the due process requirements that type of housing provider might have. So that's another reason why where there's any sort of question, landlords should err on the side of going to court. If someone is improperly evicted through extrajudicial means, such as locking them out, turning off their utility service, some other type of non-court order type eviction. Tenants have pretty significant legal remedies for that. Specifically for the disruption of utility services, the statute provides for a $300 per day statutory damage, $300 per day that they're deprived of the service. If it's a lockout type situation where the person is deprived of the entire property altogether, the statute doesn't actually specify any specific amount, although I think it's likely that a court would find that that's more than 300, since not only are you deprived of all your utilities, but also the actual property itself. Tenants can also recover costs and attorney fees, and so they can usually find private lawyers to bring these cases. There's additional remedies available that people who are locked out can sue. So landlords can face some pretty significant financial liability for improperly resorting to extrajudicial evictions. Some other things that I thought were relevant to survivors of domestic violence, sexual assault, or stalking in Washington. In I think 2004, Washington passed what's called the Victim Protection Act. It basically prohibits housing discrimination against survivors of domestic violence, sexual assault, or stalking. So that includes in the application process, it includes in the eviction or lease renewal process. It also has a pretty extensive provision that entitles someone who experiences domestic violence, for instance, to terminate a rental agreement early and move out of the property without owing any more of the rent that would come due under that lease. And it also entitles someone who needs to have their locks changed to prevent an abuser from getting access to the property. The statute entitles the person to ask the landlord to change the locks, and the landlord has to do it. So there's also a provision that was added, excuse me, just I think last year, which also makes it unlawful for a tenant screening company. This is a consumer reporting agency that prepares background checks on rental applicants, for instance, to disclose that someone has the status of being a survivor of domestic violence, sexual assault, or stalking in a tenant screening report. So these protections are actually quite similar to what's available under a federal statute called the Violence Against Women Act. Now, the federal statute only applies to housing providers that receive federal funds. We're mostly talking about HUD-funded programs such as public housing or what's called project-based Section 8. These are buildings that have contracts with HUD to provide affordable housing, rural development projects through the USDA. Importantly, the what's called the Low-Income Housing Tax Credit Program. This is actually the largest active low-income housing development program there is at the federal level. It's administered through the IRS. That program is not covered by the VAWA housing provisions. But the protections are for the most part pretty similar to the State Victim Protection Act. Prevents the housing discrimination against victims of domestic violence, dating violence, sexual assault, or stalking. Of course, in Washington, the Victim Protection Act applies to all housing providers. One particularly useful part of the VAWA housing provisions is that it would require a subsidized housing provider to have a transfer policy in place. So, for instance, if someone needs to be switched to a different apartment or a different project to make it more difficult for an abuser to find them, these covered providers have to develop those policies and abide by them. So, another issue that we've continued to see is what happens when there's property damage that may be caused in the course of an assault or caused by the abuser. Who's liable for that? What Washington statute provides is that the tenant shall not intentionally or negligently damage the property or permit any member of the household or a person acting under his or her control to do so. So the position that we've always taken at Northwest Justice Project is that someone who's engaging in domestic violence or sexual assault or something of that nature is not acting under the tenant's control. Even if the person may have been admitted to the property by consent, at the point where that person refused to leave or started doing the assault, it's really not reasonable to expect that the tenant has control over that person, so that the tenant should not be liable for that kind of damage. Unfortunately, there haven't been any reported court decisions actually holding that. We did have a case at NJP that settled earlier this year where a court had basically agreed with us on that theory at the trial court level, but the case settled before it was appealed, so that decision won't set any kind of precedent. But that's an argument that we continue to make. Last, I normally give presentations on this topic that can last quite a while. I've kind of tried to condense it down into one slide, but what are some things that people who have been victims of domestic violence, sexual assault, or stalking can do to overcome barriers they might have to obtaining housing somewhere else? And again, this is just a very quick overview of this. First of all, it's important for people who are concerned about being turned down for rental housing to try and either get rid of or at least minimize any legitimate grounds they might be facing for denial. So for instance, if they have blemished credit, or there's a question about whether they make enough money to afford the rent and so forth, they'll want to make sure they address that either by getting a new job so that they have enough money to pay the rent, or if they get some kind of public benefits or housing voucher, for instance, that can address that problem. If there's misleading information on their credit report or on some kind of criminal background check or something that they can dispute and get cleared up, it's important to try and do that. A legitimate rental collection, meaning money that they actually do owe the landlord, a past landlord, for unpaid rent or damage that they caused, is almost always going to be an automatic basis for being turned down. So if they legitimately do owe the money, then they probably need to either pay that off or negotiate some kind of payment plan. Again, if it's money that they don't owe, for instance, the damage was caused by someone else, such as the abuser or something, then they may want to go through whatever steps they need to dispute that and get that cleared. And then if the person has criminal records or other evidence of having been violating the behavior obligations of a tenancy, for instance, it'll be important for them to have some kind of evidence of how they've changed since, so that the negative historical information is no longer predictive. So for instance, if they need to go to some kind of counseling or treatment, if they need to get some kind of substance abuse counseling, etc. It's important to do that first. And keep in mind that with eviction records particularly, a lot of times someone can incur an eviction record for something someone else did, especially if we're talking about situations where there's been domestic violence. It's certainly possible that just by removing the problem person from the household, that may be one way of showing that, yes, I have this eviction record, but it was because this other person, was supposed to pay the rent and didn't do it, or this other person was caused damage to the property, that sort of thing. Of course, it would be unlawful for a landlord to evict a victim of domestic violence for the domestic violence, but frankly, that has happened from time to time, even after the statute was passed as well. So, once the person can get their background report in as good a shape as possible, then it's important for them to go apply for housing and make sure they keep all their records. Ideally, copies of admission policies, if they get notices of denial, that sort of thing, if they're able to get copies of their screening reports, all of that stuff can help in basically disputing notices of denial that they get. Importantly, a few years ago, the law was changed to require residential landlords in Washington to actually give a written adverse action notice that states the reason for denial. That's been a big help, because previously, if someone was turned down for housing, the landlord only had to tell them they were denied, and they didn't have to say why, and they didn't have to put anything in writing. And so you could pull the person's background check and see, oh, well, they've got this criminal record, that must be the reason, and you would provide evidence of rehabilitation, and the landlord would say, oh, actually, it was their credit report or something. With the requirement of a written adverse action notice, it's made it much more difficult it's made it much easier to dispute these things because it's not so much of a moving target. Last, if someone is turned down and the reason just seems, I'd say, objectively questionable, it just doesn't seem fair. It seems like it might be discriminatory, or the information the landlord's acting on is pretty specious. These are cases that we take at NJP, cases we actively look for, actually, and so we'd certainly be interested in referrals of people who get turned down for reasons that just don't sit right with people. But I think that's my last slide. So at this point, I'm ready for any questions people would have.
I've been watching the chat box, and I haven't seen any questions coming up. While you think about that, and I'll also, oh, I see a hand. Okay, Heidi, I will unmute you so you can ask. Heidi? Heidi, are you there? Heidi, maybe since I have unmuted you and I see your hand is up and I'm not hearing anything, are you able to try the question box and do it that way? Okay, Heidi, I'm going to move on to Shannon, who also has her hand up. And Shannon, I'll try to unmute you. Let's see. Okay. Shannon, it is not working for me to unmute you. Could you please do the question box at the bottom? I see Heidi says that she'll write in her question. Shannon, if you could do the same thing, that would be tremendous. So Shannon and Heidi are working at writing in their questions. Shannon, I hope you're trying to do that too. I think just in reflecting on my own years as a shelter director, some of the challenges is we kind of fall right in the middle of the different categories, the two categories. That we don't have signs in front of our shelters, and that we are trying to allow more autonomy and for people not always to share their living space, even with communal living shelter. And we try to allow people to come and go and have ways to get in and out without that being under staff control. So that can be a little challenging, and Eric, what I'm hearing from you is that it is best to err on the side of, I don't know, caution. Would that be a good way to put that?
Yeah, well, I mean, as I pointed out, I mean, whether someone's status is going to be determined to be a tenant or a licensee, really depends on this set of reasonable person factors. And, ultimately that's something that would probably not be known in a given case, unless someone actually filed a lawsuit and, court determined it. But if a court were to determine that, yeah, this person was a tenant and, they should have been given notice and a chance for a hearing, and that had, they couldn't be removed without a court order, and they weren't given the notice, they weren't given the hearing, they were evicted without a court order, well, then, you know, the property owner that removed them, you know, without going through those steps is liable, and potentially for a pretty significant amount of money.
Mm-hmm.
Whereas if you know, if a facility does go through those steps, even if it turns out, you know, that they wouldn't have had to, at least they've covered their bases.
Okay. I'm still watching for written questions coming in. I'm hoping that there aren't logistical problems. Heidi, are you there? Shannon, are you writing?
Hi, this is Judy. We have questions from Shannon, Sally, Heidi, and Shannon again, and Heidi again. So for some reason, I don't think that they're showing up for everyone, so I'll read them.
Oh, thanks, Judy.
Okay, so Shannon says, I'd like to know more about the housing incidental to services. Does this apply to DV programs, both transitional and shelter? Shannon also says, also wanted to know more about programs serving a specific cultural population. For example, ADWA's, Abused Deaf Women's Advocacy Services. Being told by FHC coordinated entry that they have to take everyone, even if there are survivors who are not part of the cultural community that program was formed to serve. And then Shannon's last question is...
Can I do these like one at a time?
Yeah. So the first question again is, I'd like to know more about housing incidental to services. How does this apply to DV programs that provide transitional housing and shelter?
Okay, well, transitional housing is pretty well established as a form of rental housing. So, but what the housing incidental to services exception is for is where the housing really is kind of tangential to the reason the person is there. You know, again, I think the hospital may be the best example. Another one is like a college dormitory. The person is there for education, but they happen to live in a dormitory. It's exempt from the Landlord-Tenant Act. What the significance of that really is that the landlord does not owe the same duties to that person that residential landlords owe under the state Landlord-Tenant Act. And tenants in those situations, or people living in the housing in those situations, don't owe all the same duties as tenants, and they don't have the same rights that tenants would have. But that being the case, when it comes to the eviction / removal scenario, college dormitories, still need to actually evict people, or they're supposed to anyway. A hospital would not, because if you're at a hospital, the housing aspect of a hospital is so tangential to the reason that the person is there, that person would be considered a licensee. Transitional housing facilities so closely resemble rental housing usually that those people are generally going to be considered bona fide residential tenants. But then some of the other shelters, I mean, it's sort of this continuum. The more tenuous the person's access to the housing is, the more likely they're a licensee. But it's really depends on a case-by-case scenario. I hope that answers the first question. I think there were some others.
Judy, are you there?
Judy, yes, I'm starting to post a couple of questions here, so I hope that they're showing up for everyone. Shannon's second question was regarding a shelter program that's serving a specific cultural population. for example, ADWAS, Abused Deaf Women's Advocacy Services, they're being told by FHC Coordinated Entry that they have to take everyone, even if those survivors are not part of the cultural community that the program was set up to serve.
Well, this is an interesting question.
Eric, I would just add that I think the the logic that's being presented is that it's a fair housing issue.
Yeah, you know, I don't. Well, of course, under the Fair Housing Act, I mean, it's basically illegal to discriminate on the basis of membership in any protected class, and that would include something like ethnicity, national origin, you know, cultural identity type things. And so I think somebody could argue that if a program has a policy of only admitting individuals who belong to a particular ethnicity or you know, cultural, you know, religious type affiliation or something like that, then they're unlawfully discriminating against you know, people who don't belong to that particular group. But there are some exceptions for things like in the employment context, they call it a bona fide occupational qualification. I guess this would be like a bona fide housing qualification or something, where if you show that, you know, the whole point of this program is to provide services to this particular ethnic group, you know, a lot of times that can be a valid justification. I don't know if there's been any litigation clarifying this. I know that some people who are, you know, not particular fans of affirmative action, you know, have been pushing some of these types of theories. So, you know, I can't really say what would happen if it went to court. But I think there's at least a reasonable argument that a housing provider that, you know, specializes in providing services to a particular ethnic group or, you know, affinity group of some kind, you know, probably can limit its admissions to, or at least prioritize admissions to members of that particular group.
Okay, so Eric, this is Judy again. Could you please define what is a protected class?
Well, we have anti-discrimination laws at the federal level, at the state level, and a lot of local cities and counties have their own. And so each of those different statutes will define the groups that they protect from discrimination a little bit differently. And then there are some groups that are protected under, say, the state law, such as, you know, for instance, the Washington law against discrimination reflects sexual orientation as a protected class. The federal law does not. You know, and then I think Seattle's open housing ordinance, you know, goes into much more detail about what that actually means. But a protected class is basically anyone who belongs to one of these statutorily identified groups, you know, for purposes of, like, say, Washington's Victim Protection Act that I mentioned protects victims of domestic violence, sexual assault, or stalking from different types of housing discrimination. It doesn't necessarily protect people from discrimination in employment and so forth. So a protected class would be, you know, a group that receives protection from discrimination in a particular thing, such as housing or employment or education or public services, and so forth.
Okay, Eric and Linda, can you see the other questions that I've posted?
No, I'm afraid I'm not seeing any of the questions.
Okay, so the next question is from Sally Kim at Korean Women's Association. If a survivor has to break her lease due to domestic violence and has a protection order, is she able to get her deposit back?
Well, the answer is yes. landlord should refund the deposit the same as if she, stayed there the whole time. It would be unlawful for the landlord to keep the deposit, especially if the landlord is, claiming that she owes, money for the remaining term of the lease or for property damage that the abuser did. So yeah, the answer is yes, the deposit should be refunded.
Excellent. Okay, next question from Heidi. Since we receive HUD funds and McKinney-Vento assistance, does that change which laws excuse me, we are subject to?
Well, as we talked about before, a situation where the people who are staying at the facility would be categorized as licensees. Those folks could, if they became disruptive or for some reason it was necessary to have them removed, I think the facility actually could probably call the police and just have the person escorted off the premises for trespassing. But if we're talking about a property that's receiving McKinney-Vento funds, then the facility almost certainly has some obligation to provide due process to the person before they are removed from whatever programs and services they're participating in. Now, sometimes that notice and hearing requirement can be met through some type of procedure that doesn't involve any kind of judicial involvement. Maybe some type of hearing that could be held at the facility and presided over by, a regional supervisor or something. So that's, it's possible. But if the facility actually goes through the eviction procedure and has the person evicted by the court, then there's no question that the person got due process. Then there's no question that the person got notice and opportunity to be heard by a qualified decision maker. But a lot of times where those procedures are spelled out by a contract, there may be some other way that the facility could go about it. But usually the rule is that the more significant the benefit that's being taken away, the more notice and the better hearing procedures the person's entitled to. So if the person is actually residing at a facility, it's more likely that they're going to be entitled to a hearing at least approaching what you would get in court. Whereas if it's a program that's not providing residential type services, then it may just be some type of meeting or lesser hearing that they'd be entitled to receive.
Okay, and this question, Heidi, I know you have one more, but I want to include this one from Shannon since it seems relevant. Is Eric, what if a transitional housing program does not charge any rent or program fees?
Well, I assume the reason that for the question is how that fits into this analysis of whether the people staying there are tenants or not. And that would certainly be one of the factors that would tend to show the person is less likely to be a tenant. On its own, it's probably not enough to determine one way or another. But if you look at the sum total of things, that's, if you had a scale and you put each factor that suggested the person was a tenant, you put a nickel on one side, and then for every factor that suggested the opposite, you put a nickel on the other side and see which one weighs more. That would be a factor that would tend to put a nickel on the, person's not a tenant side. But, there certainly could be situations where a person is a tenant even though they don't pay rent.
Okay.
Yes,
Lynn?
Judy, I finally am seeing the questions, and I hope there's just about enough time to address Heidi Harding's concerns and questions about law enforcement when they respond to a call to remove someone from shelter. that they've had police refuse to do so, and I think she's asking about a handout or what they can say to police if police refuse to remove someone from shelter.
Well, I would probably suggest that the person congratulate the police officer on doing a good job. But then again, I do represent tenants.
Mm-hmm.
I will say that the City of Seattle has a kind of a model policy on how they handle these situations, which was actually developed by Steve Frederickson, who also works for Northwest Justice Project. And you know, the police have to kind of go through a similar analysis. I mean, if the police improperly remove somebody from housing and the person's a tenant and is entitled to judicial process before they're removed, and the police, you know, just take that person away, then the police are violating that person's constitutional rights, and the police can be held liable for that as well. And in fact, the individual officers can be held liable for that. So, you know, it's asking a lot of the police to make these kind of decisions, and the police, I think, similarly should be erring on the side of not intervening when they find someone, you know, living at a property who claims to be a tenant, or at least have some kind of right to not be removed except by court order. You know, I think the police really should only intervene in obvious situations where it's, you know, where it's clearly not housing, or if the person is actively involved in some type of criminal behavior, then certainly the police could arrest the person for that. But to expect the police to be putting themselves in the position of determining whether people are tenants or not is, you know, that's not really their forte.
All right, Judy, I think those are all the questions. Am I missing any now that I finally found the question panel?
I think you've got it, Linda.
All right. We are about ready to end. It doesn't look like we've got time for other questions on more general topics, so I'll just be sending out probably through your shelter Yahoo listserv, shelter managers listserv, solicitation for other questions, other topics you'd like to talk about. And if there's something that sparks your thoughts about this particular presentation, please don't hesitate to use that listserv to chat with others about it, or maybe ask more questions. So at this time, Eric, thank you so much for taking the time to be with us, to put this slide presentation together, and to walk us through a deeper understanding of Residential Landlord-Tenant Act and some of the ways that might or might not apply to our own programs. It's been great. Thanks so much, Eric.
You're welcome. Thank you.
And with that, I will sign off. Thanks, everybody.